Further hearing in the appeal of Alexander Lewis-Ranwell against G4S Health UK Limited.
Yes, Mr. Plowden.
My ladies, I finished my 10 minutes yesterday by explaining the structure which I proposed to take for my submissions. Just to put you back in the picture, that was the first part of it is our argument that there is no illegality to engage the illegality defence, and that is 3 parts: the requirement for an illegality before the defence is engaged, or turpitude; second part, what amounts to an illegality for those purposes; and the third part, to look back briefly, where I haven't covered it, about why the claimant's behaviour doesn't amount to an illegality, but with a longer look at that stage at the criminal law and how it treats insanity. That first part, with those 3 subsections, will take most of the morning, I anticipate. The other parts are shorter, just to reassure you if you think you're getting lost in it. The second part is to have a closer look at the authorities where the illegality defence has been applied in cases involving the mentally ill. And the third part of my submissions relates to the application of the trio of consideration test, if it is engaged. I'll stop there, hopefully by 3 o'clock, and Mr. Chris Johnson will deal with some other important parts of the case which are set out at the moment in the appendix. I should apologise, it was entirely my fault. I didn't notice that the appendix making its way into the core bundle had somehow lost its page numbers, and that's why you have a supplementary bundle which includes those cases which came to you in, I think, about a week or so ago.
And I do hope, Ms. Plowden, you'll bear in mind that while the existing case law is formulated in terms of behaviour which is illegal or unlawful, and that reflects the sort of cases that the courts have been looking at, the question in this case may not necessarily be determined by deciding whether this is a case of illegal or unlawful behaviour. It may be that the question might arise, just for the sake of argument, that you persuade us that the behaviour here was not unlawful or illegal. Nevertheless, it's a type of case that the court hasn't had to look at before, and the question might then be, well, do the considerations which led the court to adopt the approach it did in cases of illegality well, on the one hand, the coherence of the legal system, public confidence, do those considerations apply to a case such as the present, so as to justify an amplification, if you like, of a category of case that falls within the rule? Or, on the other hand, as the Court of Appeal considered, are considerations of culpability and moral responsibility and so forth, are they of critical importance so that there should be no extension of a rule? All I'm trying to indicate is that focusing really on the word unlawful, we shouldn't lose sight of what may be a slightly bigger picture.
Thank you, my Lord. It was very helpful to have that indication, and I hope that's the approach I plan to take and do take.
Thank you.
But we do, of course, say that it's important to look at the cases where there was a criminal offence and the rationale and the policy reasons behind that,
yes,
in order to see why it's applied in those cases and why it was thought in Henderson, for example, that it wouldn't go on to apply to an incident. So that, I suppose in short, our point is that the distinction is principled and based on sound policy. The first part then of my submissions is that there is a requirement for an illegality or turpitude before the defence is engaged, what's been referred to as a threshold test. We deal with that. I can tell you the section of the written case, but I'm not asking you to turn there now, but at part C of the written case, which is at paragraph 11 onwards, at page 227 of the core bundle. The claimant's position in relation to this is that the need for a turpitude, I use the word because it's clear that it is in that broader sense than just illegality, to engage the defence. It's axiomatic.
So, sorry, what do you mean by turpitude then? You don't just mean illegality.
Well, I have to accept that, that the way in which the statement was classically put by Chief Justice Mansfield back in 1775, and where everybody starts, I think, is that no court will lend its aid to a man who founds his cause of action on an immoral or an illegal act. And so there is an understanding from early on in the application of the defence that it may, or there's an implication there, that it may be something a little wider. And that is certainly a part of Lord Sumption's judgment in Apotex, which I'll come on to look at. But we do say that the illegality defence or the ex turpi causa defence does require, before we can engage how to apply it, does require a turpitude or an illegality. And that is clear from not only the classic statement of it, but from the rationale and the policies which underlie the defence, not permitting the claimant to profit from wrongdoing, and consistency within the law, not condoning illegality by giving with the left what it takes with the right. There is nothing in our submission in the restructuring of the law in Patel and Mirza, or in its application since that, which alters the need to identify the turpitude. And demonstrate that briefly, I hope, by reference to some key passages in Patel and in Henderson, before going on to consider the related question of what amounts to a turpitude for these purposes. If I can take you directly to Patel and Mirza. I seem to have lost my link. To page 2280 of the bundle. And before, well, I'll ask you to read paragraph 99 to give it context, and 100 and 101. We see towards the bottom of paragraph 100 that Lord Toulson here has cited Hall and Hebbert and the judgment of McLaughlin J. And notes the question which she considers the courts ought to focus on. The question which ought to be focused on is whether allowing recovery for something which was illegal would produce inconsistency and disharmony in the law, and so cause damage to the integrity of the legal system. 101, that is a valuable insight with which I agree. And Lord Toulson goes on, so in answer to that question, the question of whether allowing recovery for something which was illegal, in answer to that question, I would say one cannot do so without, and then the trio of consideration test. And we say, submit, that the question that the test is designed to answer is that how to decide whether a claim which is affected by illegality should be allowed to proceed and whether recovery should be permitted, and is not how to decide whether or not the claim was affected by illegality. And you can see that more clearly, I think, in paragraph 109 of Lord Toulson's judgment, which you've just scrolled down is probably the best way to come to that. And it's this, starting on the second line, I conclude that it is right for a court which is considering the application of the common law doctrine of illegality to have regard to the policy factors involved and to the nature and circumstances of the illegal conduct in determining whether the public interest in preserving the integrity of the justice system should result in denial of the relief claimed. I put it that way, so in determining, I put it that way, rather than whether the contract should be regarded as tainted by illegality, because the question is whether the relief claimed should be granted. So the test is designed to determine whether allowing recovery for a claim which has been affected by an illegality would damage the integrity of the law. It's not a test to determine whether a claim has been affected by an illegality. I can't remember quite who yesterday, but there was some emphasis placed yesterday by the appellants on the fact that Lord Toulson uses the phrase tainted with illegality. In my submission, that's a comment on the relationship between the illegality and the claim. It's not a comment on the whether there's an illegality or not. It doesn't soften it so that there's no need for an illegality. In Henderson, this court proceeded on this basis, where Lord Hamblin had summarised the question and the test at paragraph 65 for your note. But a part of the argument, a central part of the claimant's argument in Henderson was that there was no turpitude to engage the defence, and because of her reduced or seemed to be lack of significant personal responsibility for the killing of her mother, which was comments made by the sentencing judge. I'm sorry, I've rather assumed knowledge of the facts of Henderson. Lord Hamblin addresses this threshold test separately to, and before he goes on to consider the trio of consideration test, at paragraph 112 of the judgment, which is at page 1744 of your bundle. And Lord Hamblin says here, finally, the appellant advances a related argument that the lack of significant personal responsibility means that there is insufficient turpitude to give rise to the illegality defence. This again ignores the seriousness of a criminal conviction for manslaughter. He details that. The plea of guilty to manslaughter by reason of diminished responsibility means acceptance by the appellant that she possessed the mental prerequisites of criminal responsibility for murder, namely an intention to kill or to cause grievous bodily harm. And in the present case, the expert psychiatrists also agreed that the appellant knew what she was doing was morally and legally wrong when she inflicted the stab wounds on her mother. I might add there that if they'd said otherwise, she would have had a not guilty plea available to her. But in Les Laboratoires Servier and Apotex, Lord Sumption stated at paragraph 23 that the paradigm case of an illegal act engaging the defence is a criminal offence. As Lord Sumption explained at paragraph 29, there may be some exceptional cases where a criminal act will not constitute turpitude. The reservation made in Gray in relation to trivial offences may be an example of such a case. The serious criminal offence of manslaughter by reason of diminished responsibility does not come close to falling within such an exception and clearly engages the defence. The submission I make in relation to that is that in response to a submission that there is a threshold test, the answer was that there isn't. We go straight to Patel and Mercer and the trio of considerations, but was to engage with that, and to do so with express reference to Lord Sumption's judgment in Apotex, where he had considered what constitutes a turpitude.
But this was a paradigm case. There was a criminal offence.
There was.
And Lord Hamblin didn't focus on the degree of personal responsibility or culpability. That didn't come into the equation.
The fact of
it was the fact of a criminal offence
would have been sufficient.
Yes.
I have some submissions about whether that was of relevance, because that's a part of the case later. But yes, yes, a criminal offence would have been sufficient.
Yes.
The point I'm making is perhaps a simpler one, is that he doesn't object to the test or to looking back to Apotex to see, well, what is the, what can amount to a turpitude or not. It's directly applied. And in my submission, that must be right, because there's no suggestion in Patel and Mercer, or indeed in Henderson, that this court intended to broaden the reach of the illegality defence so that courts would be, to broaden it so far that courts would be obliged to weigh policy reasons before deciding whether to adjudicate any claim uncoupled from a requirement for an illegality or a culpable wrongdoing. It's a proposal that we add an extra layer of litigation in at each stage. And that brings me to the second part of this question, which is, what is a turpitude or an illegality? And that is dealt with in our written case from section D, which is from paragraph 15 at page 228 for your note. But the most comprehensive discussion of what amounts to a turpitude is Lord Sumption's judgment in Apotex, as referred to by Lord Hamblin in Henderson, as we've just seen at paragraph 112. And our submission is that Apotex remains authority for the proposition that, with few exceptions, the defence is only engaged where the illegality involves criminal conduct, or what he calls quasi-criminal conduct, which involves some closely analogous situations which we'll look at. And the Supreme Court in Patel and Mercer didn't depart from this aspect of Apotex. It wasn't considering this question, of course, because in Patel there was a criminal offence. It involved criminal behaviour, the intention or the conspiracy to commit insider dealing. Some time will be we need to spend with Apotex, but and some related authorities. I've structured the submissions in this way, around the sort of categories of information which Lord Sumption uses in his judgment in that case. Firstly, the claimant's criminal conduct. Where there is criminal conduct by a claimant, we say that almost always engages the defence. Secondly, the claimant's quasi-criminal conduct, which engages the defence. The culpability of the claimant, which we say is a necessary ingredient to engage it. And fourthly, and relevant to this case, the tortious behaviour of a claimant or a civil wrong. And we say that, save with few and immaterial exceptions which cause such tortious behaviour to be elevated to criminal behaviour or quasi-criminal behaviour, that does not engage the defence, both as a consequence of Apotex, but also, and the authorities before it, but also on the basis of sound principles and policies. I take the submissions in that order, but it's at the end, pulling them together, I think that one can look at it in the round, because culpability, of course, plays into the different parts. So in relation to then the first of those, a claimant's criminal conduct, as an observation, only in very rare cases has the illegality defence been engaged where the relevant behaviour of the claimant was not criminal. And we say that's evident from the authorities, but particularly so when the illegality defence is being raised in order to defeat a claim by a claimant for tortious losses, a personal injury claim such as this. And we note that the defendants have not identified a single tortious claim previously debarred by the illegality defence on grounds other than the claimant's criminal behaviour, and that nor, say for one exception, could the Law Commission, or did the Law Commission do so in its 2001 paper, the illegality defence in tort, the consultation paper.
But how does that work? If the criminal offence has a certain mens rea and you rely on the criminal conduct in your tortious claim, but you don't have to prove intentional recklessness, it's enough if you prove negligence. So how can you tell whether the conduct which is being relied on in the tortious claim was actually criminal in every case?
Our short answer to that would be where you have been acquitted of the crime and found not guilty because you didn't have the responsibility or ability to know right from wrong, to be able to have the capacity to it doesn't really make sense in those circumstances to talk about the mens rea of would you have had this or that, because the insanity defence goes beyond
You said, I think you said, it's only in very rare cases illegality defence has been engaged where the conduct was not criminal. But then I thought you said, even if the claim is based in tort, the conduct has been relied on, has been criminal.
Sorry, I think I've been unclear there. Yes. Only in rare cases has the illegality defence been engaged where the relevant behaviour was not criminal, where the illegality. In the case of tortious claims by a plaintiff claimant for personal injuries or similar circumstances, we say, for one exception, as far as we're aware, it has never been applied in the absence of criminal behaviour. And was intending to go on to develop why that is the case and why that is sound. Does that answer your question? Yes. Not fully. There's so many parts to this. But the exception in the consultation paper by the Law Commission was a case of Hegarty and Shine from 1882, where immorality was held to be sufficient. The immorality at that time was cohabitation outside of marriage. And as the Law Commission acknowledged, it would be highly unlikely to apply today. And the Law Commission recognised that there may be a category of gross immoral conduct, something going beyond criminal conduct, which could raise the defence.
Have you got a page reference for that?
Sorry, I apologise. Yes, it's page 4621.
Oh, we have a report at page 1645.
Oh, yes.
Oh, Hegarty and Shine, we do.
I think that's the case, isn't it? 1878, 14 Cox's reports.
Yes.
Page 1645.
1645. And so 4621 is a reference to the Law Commission report.
Yes.
Law Commission consultation paper, is it?
Consultation paper, where they had undertaken a review of the law to that stage. And it's at paragraphs 1.14 onwards that they're making the point that...
Thank you.
and we align ourselves with that view that whilst it may be that there is grossly immoral conduct which could amount to an illegality or turpitude, it's hard to envisage today what would be immoral if not criminalised, but not relevant for this purpose, where we say there was no...
This is an Irish case, I see.
It is an Irish case, yes. Oh. We deal with it briefly in a footnote at page 229 of our written case.
Well, it's an absorbing read, but perhaps we'd better make progress.
Perhaps I underestimated noting it. I meant as a passing sentence, it's really uncontentious that the illegality defence has not been raised to defeat a tortious claim, save where there's been criminal conduct by the claimant, and there has been none here, we say. And the lack of that authority is to be expected in my submission, given the rationale behind the defence of consistency in the law and integrity of the legal system. And it is to that consistency policy that Lord Sumption refers when he's explaining why it is criminal acts which justify the application of the defence. And I'm going to take you to Apotex. It's at paragraphs 23 from page 1890. You can see that he's asked the question, what is turpitude? And I won't ask you to read all of this now because I want to trace through the question about why it's criminal conduct which engages it. But you see the first sentence in paragraph 23, the paradigm case of an illegal act engaging the defence is a criminal offence, so much so that much modern judicial analysis deals with the question as if nothing else was relevant, and he goes on to broaden it for a part. But in searching for the rationale for that and identifying the consistency principle, he comes at the top of paragraph 24 to explain, in Lord Mansfield's day, 1775, and for some time thereafter, this rule of abstention was sometimes expressed as a principle protecting the innocence or dignity of the court against defilement.
Well, that was what they were saying in the Hegarty and
Yes.
Shine case. This is not the kind of inquiry that a court should be making.
So he was, yes, thank you. I think that importantly, he goes on to say there that today it's just at the top of the page, next page down. Today, the same concept would be expressed in less self-indulgent terms as the principle of consistency. And he cites McLaughlin J. in Hall and Hebert, where the consistency principle is most fully explained. I don't want to gallop if it's helpful to pause there, but demonstrating that he makes the link. It's a criminal act, and that's because of the consistency principle. And if I can take you just to Lord Sumption's judgment in Patel, and I appreciate, of course, that he was in the minority as to the test which should be applied to an illegality. But in this part of the judgment that I take you to, he was on all fours with the majority of the court in considering the underlying rationale for the defence. And I was going to take you, please, to page 2314 of your bundle. And at about, you can see that he has been looking at the judgment of McLaughlin J. again in more detail here, and he cites her conclusion there, just below E. Her conclusion at pages 179 to 180 was that there is a need in the law of tort for a principle which permits judges to deny recovery to a plaintiff on the ground that to do so would undermine the integrity of the justice system. The power is a limited one. Its use is justified where allowing the plaintiff's claim would introduce inconsistency into the fabric of the law, either by permitting the plaintiff to profit from an illegal or wrongful act, or to evade a penalty prescribed by the criminal law. He goes on at paragraph 231, just below it. In practice, the illegality principle has almost invariably been raised as a defence to a civil claim based on a breach of the criminal law. In Les Laboratoires Servier and Apotex, this court held that with immaterial exceptions, the defence is available only in such cases. This conclusion tends to reinforce the significance of the principle of consistency as a rationale. The civil courts of the state cannot coherently give effect to legal rights founded on criminal acts, which are contrary to the state's public law. There is no reason to regard this as any less important according to whether the civil claim lies in a contract or tort. But he's linking the reason it's criminal acts to the facts of the consistency principle. This conclusion tends to reinforce the significance of the principle as a rationale. And he's summarized, in effect, his understanding of what the court held in Les Laboratoires and Apotex, save with exceptions which were immaterial in Patel. The defence is available only in such cases. Just before leaving this part of the judgment, can I ask you to scroll down to paragraph 232 and to just note, it's about halfway down, just above C, where he's looking at Lord Hoffman's judgment in Gray, and I take you to this because it's a passage which is later cited with approval in Henderson. So he's noting from just above D that Lord Hoffman was inclined to think that the wider rule that a person cannot recover for damage which is the consequence of his own criminal act was based on a different principle than the inconsistency principle for the narrower recoveries, and was concerned with the public notions of the fair distribution of resources. And Lord Sumption says, certainly the inconsistency of awarding damages representing loss arising from a criminal sentence is more obvious and direct than it is where the claimant is claiming other damages, causally flowing from his commission of a crime. But it seems to me, as it did to McLaughlin and those who've adopted her approach more generally, that the internal coherence of the law is also the reason why it will not give effect in a civil court to a cause of action based on acts which it would punish in a criminal court. I emphasize the role of crime and condemnation and punishment in those. And he cites from Hunger and Allen, Lord Hughes, the law must act consistently. It cannot give with one hand what it takes away with another, nor condone when facing right what it condemns when facing left. So, drawing this part of it together, just insofar as the criminality is concerned, I think we've noted that it's uncontroversial that with very few exceptions, the defence is applied outside of where there's a criminal act. And to apply it to a claim in tort, such as this claim, where there is no crime, would be to extend the reach of the illegality defence beyond where it has previously been applied. It takes me to the second category of cases. Sorry. To race ahead of the pens, but the second category of cases that Lord Sumption considers of quasi-crime, the second part of this submission, that the and this is dealt with at paragraphs 19 to 21 of our written case, page 229. But quasi-crime or quasi-criminal conduct is a phrase used by Lord Sumption in Appellants at paragraph 25, and so that's at page 1891. It's a relatively short paragraph, but I'll read it out. The ex turpi causa principle is concerned with claims founded on acts which are contrary to the public law of the state and engage the public interest. The paradigm case is, as I've said, a criminal act, but in addition, it is concerned with a limited category of acts which, while not necessarily criminal, can conveniently be described as quasi-criminal because they engage the public interest in the same way. And leaving aside some special cases of contracts, he says, this additional category of non-criminal acts giving rise to the defence includes cases of dishonesty or corruption, which have always been regarded as engaging the public interest, even in the context of purely civil disputes, some anomalous categories of misconduct, such as prostitution, which, without itself being criminal, are contrary to public policy and involve criminal liability on the part of secondary parties, and the infringement of statutory rules enacted for the protection of the public interest and attracting civil sanctions of a penal character, such as the competition law considered by Mr. Justice Flo in Safeway stores. We note from that passage and the consideration of quasi-criminal acts that Lord Sumption included there dishonesty and corruption, misconduct which involves criminality on the part of secondary parties, infringement of rules which, whilst not criminal, have a punitive effect. All of those, we say, engage the underlying policies of the illegality defence, at least in one way or another. Either they offend against the principle of consistency in the law, civil fine to punish an environmental firm on the one hand, but then compensating it again, or they involve profit from wrongdoing, knowing commercial gain from something which would amount to wrongfulness. And the reason that's important to note is because when he says a quasi-criminal act is the same as a criminal act because it engages the public interest in the same way, in the same way as crime engages the public interest. And the public interest where the illegality defence is concerned, and where crime brings it in. It is, I haven't put that very clearly. Let me just rephrase that. I'm asking myself the question, or asking you to ask yourselves the question, what does he mean by engage the public interest in the same way? It's implicit in that he means in the same way as a crime. And the public interests with which the illegality defence is concerned, when looking at criminal behaviour, so in the same way as a crime, are to ensure that you prevent the claimant from profiting from wrongdoing, and the linked and primary public interest of preventing inconsistency damaging the integrity of the law. And in a tortious claim, such as Mr. Lewis-Ranwell's, it's not as seeking to profit. And we submit there is no inconsistency. Contrary is true. To permit his claim to continue, not to treat him as a criminal, would be consistent with the way in which the courts treated him in the criminal case. Whereas the examples which Lord Sumption gives of quasi-criminal illegalities all involve behaviours underlying those policies which are deserving of condemnation or punishment. And it was not here. He didn't deserve or receive condemnation or punishment, and it would not be inconsistent or introduce inconsistency into the law to permit his claim to continue. And that I appreciate. There is a question around tort, and then we'll come on to look at that in a moment. The third of the four categories which I identified at the beginning was culpability. As I said previously, we do say that culpability is an essential ingredient of the illegality defence. In our case is that there's a strong line of authority that the defence does not apply without culpability, that no case has been cited by the appellants where the defence has applied absent culpability. And there are, again, sound reasons and justice, as well as the original maxim behind this. The defence is concerned with the claimant's culpable wrongdoing. Wrongdoing, culpability. You can't divorce in our submission the one from the other. You don't have a freestanding immoral act without an immoral actor. And looking at that strong line of authority, there is a pressure of time, of course, in all submissions. And so I do refer you to our written argument, but also to the judgment of Lord Justice Underhill in the Court of Appeal. You can see from this is page 278 of the bundle, that Lord Justice Underhill has reviewed cases concerning culpability which did not involve mental illness first, from paragraphs 32 to 38. And then he keeps this issue in mind, the question of culpability, as he undertakes a detailed review of the application of the defence to the mental health cases here and abroad over the next approximately 50 paragraphs. It's something I can't do justice to here by going through all of those cases. But we do rely on the view which we say Lord Justice Underhill was unavoidably the case, and Lord Justice Underhill rightly arrived at paragraph 87 of his judgment, which is at page 297. That the general tendency of the authorities can be against the illegality defense applying in an insanity case. And then he goes on in the next sentence, there is a consistent focus on the simple proposition that it is wrong, or in Best CJ's words in Adamson and Jarvis, contrary to reason, justice, and sound policy, to treat an otherwise good claim as barred because it depends on an unlawful act done by a claimant who had no knowledge that he or she was acting unlawfully and therefore is not morally culpable. And that proposition is applied in several cases where the relevant lack of knowledge was the result of mental illness. So in answer perhaps to the point raised earlier by my Lady Simler, we do say that it, of course, the criminal conviction itself would have been enough to take you straight to Patel and Mirza, and likely all the way through as it did in Clunis, Gray and Henderson. But there is also an emphasis in those cases on the reason for that lack of criminal culpability, which is the lack of moral culpability. And that echoes down through the case law. And that's something I hope to draw out later today when I come to look at those precedents and the cases from the Commonwealth. In his Lord Justice Underhill's review of the law, he considers paragraph 29 of Lord Sumption's judgment in Apotex, where Lord Sumption is addressing a class of criminal acts which do not engage the defence. And Lord Justice Underhill says he's considering culpability at this point, and that must be right.
Where are you reading from?
So I'm going to take you, if I may, to 1893, to the judgment in Apotex. Yes, it's just below G. I'm just trying to... In paragraph 29, just to begin at that, which is on page 1892, he starts it at the bottom of that page. It's right to add that there may be exceptional cases where even criminal and quasi-criminal acts will not constitute turpitude for the purposes of the illegality defence. And he goes on to consider such cases. And he concludes at the bottom of that paragraph, just below G, something which, he concludes just below G about the need to have an inquiry into moral culpability if there has not already been that established by the defence.
This is G on the next page.
So G on page 1893. The paragraph starts with a reference to Askey and Golden Y. But if you look at it starts from the application, the part I'm referring to. The application of the exception for cases of strict liability may require a court to determine whether the claimant was in fact privy to the illegality. To that extent, an inquiry into the claimant's moral culpability may be necessary in such cases before his act can be characterized in law as turpitude. Because, of course, in an offence of strict liability, the fact of the offence tells you nothing about the state of mind of the claimant. So to that extent, an inquiry into the claimant's moral culpability may be necessary in such cases before his act can be characterized in law as turpitude. This may be a difficult question, but it isn't a question of degree. The conclusion will be a finding that the claimant was aware of the illegality or that he was not. And then he goes on to say it's a long way from the kind of value judgment implicit in the search for a proportionate relationship. Well, we say, of course, it comes back in then degrees of the prerequisite for the threshold test is that there is culpability. If the trio of consideration test is engaged, then at C, of course, one is engaged now in that search for, if you like, the contours of the culpability, how intentional was the gross negligence, for example. And in our submission, there has, of course, been such an inquiry into the claimant's state of mind in this case. There was the 2-week trial where the only question for the jury was essentially that, did the claimant know that what he was doing was wrong, the defendant in the trial? It may be difficult, but it's what juries grapple with, exactly the sort of question that juries grapple with, fine distinctions between guilty or not guilty in many criminal cases. But he established to their satisfaction on the evidence that he was not criminally liable because he did not know what he was doing was wrong. And that means he wasn't, submit also, morally culpable. And that it was Lord Sumption's view that the illegality defence requires culpability can be seen clearly in a passage from him in the case of Bilter. And Bilter, I'm straying off my patch too far, completely different facts. But I think it is helpful just on this point which he makes in a wider way there. And it's at page 1249 of the bundle, 1249. And paragraph 70, we're in the middle of it, but at the bottom of paragraph 70, just above paragraph 71. And what's being discussed, this part of the judgment is director's responsibility and attribution, whether it's necessary to attribute the illegality to an acting mind, an individual. But Lord Sumption says this: as cases like this illustrate, if the illegality defence were to be engaged merely by proof of a purely vicarious liability, it would apply irrespective of any question of attribution to any case in which the human wrongdoer was acting within the scope of his employment. This would extend the scope of the defence far more widely than anything warranted by the demands of justice or the principles stated by Lord Mansfield, on the footing that the attribution of culpability is essential to the defence. The concept of a directing mind and will remains valuable. It describes a person who can be identified with the company, either generally or for the relevant purpose, as distinct from one for who the Act's company is merely vicariously liable. But the point is that attribution of culpability is essential to the defence. And that, in my submission, is clear from a plain reading of paragraph 29 of his judgment in Apotex. And in Henderson, Lord Hamblin cited and applied paragraph 29 of Apotex when faced with the arguments on Mrs. Henderson's behalf that there was insufficient culpability to engage the defence. To draw that together, authorities at the highest level, we say, as well as for the longest time, support this threshold requirement for culpability and knowledge of wrongdoing.
So you say, he says that if the case was one of strict liability, then you do have to investigate what actually was the state of mind of the claimant.
He says you may have to.
You may have to.
Because just the fact of an offence of strict liability won't in and of itself tell you that you have a guilty mind.
If the conviction by the jury of an offence which involves a mens rea, then you don't look behind that as they were trying to do in Henderson, to say, well, even though she was convicted of this, in fact, she wasn't morally responsible.
And because diminished responsibility, your responsibility is diminished, but it's not extinguished, and that she, on the evidence, knew what she was doing and that it was wrong, and by accepting the plea of diminished responsibility, she was doing that as well. It was suggested yesterday that she might have made a forensic choice to plead differently, but on the evidence as we know it from Henderson and from the way it was summarised, that she couldn't have done, wasn't available to her, insanity wasn't available to her. So the last part of this part of my submissions, the question of what is a turpitude, relates to whether a tort or civil wrong, in our case relevant, the tort, can amount to an illegality sufficient to engage the defence. And in a sentence, our answer to my submission, the answer to that is it can, but only in circumstances where it involves behaviour which also amounts to criminal or quasi-criminal behaviour, and where it involves culpability. Lord Sumption considers in Apotex the question of whether a tort or civil wrong could amount to an illegality. And if I ask you to turn to page 1891 of your bundle. At paragraph 26, which is at F on 1891, Lord Sumption says there are dicta which suggest that the ex turpi causa principle may be wider than this, wider than the criminal, quasi-criminal categories, and that it may be engaged by a purely civil wrong, such as a tort or breach of contract. And he goes on to consider dicta in Burroughs and Rhodes and other cases said to support that in the argument. And he concludes at paragraph 28 of his judgment. Well, he concludes in his review of that the dicta is effectively unsupported and not supported by any well-reasoned authorities, save where there has been dishonest behaviour, which he had included in his category of exceptions.
Where do we see that?
You can see his consideration of the cases from paragraph 26 and 27. Perhaps I quietly let you read that before coming to this conclusion. And at paragraph 28, and it's an important paragraph, he concludes, apart from these decisions, the researchers of counsel have uncovered no cases in the long and much litigated history of the illegality defence in which it has been applied to acts which are neither criminal nor quasi-criminal, but merely tortious or in breach of contract. In my opinion, the question what constitutes turpitude for the purpose of the defence depends on the legal character of the acts relied on. It means criminal acts and what I have called quasi-criminal acts. This is because only acts in these categories engage the public interest, which is the foundation of the illegality defence. It's only where they engage this same interest. Torts, other than those of which dishonesty is an essential element, breaches of contract, statutory and other civil wrongs, offend against interests which are essentially private and not public, and there's no reason in such a case for the law to withhold its ordinary remedies. The public interest is sufficiently served by the availability of a system of corrective justice to regulate their consequences as between the parties affected. Mr. Warnock, I think, yesterday took you to the judgment of Lord Toulson in Apotex. I just wanted to make a few additional comments about the approach of Lord Toulson in Apotex. That begins at paragraph 46, which is page 1896. And the broad point is that the judgments of Lord Sumption and Lord Toulson are very similar for a long way through the laboratoire. Lord Toulson also considers, I got the right page, sorry, 1896.
That's hit the start of his judgment.
Yes. I had myself on the wrong page, thank you. Yes. So Lord Toulson comments at paragraph 46, or says at paragraph 46, in this appeal, Servier is attempting to extend the doctrine of illegality beyond any previously reported decision in circumstances where I see no good public policy reason to do so. The identified illegality in this case was the contravention of the Canadian patent. I'm assuming, again, knowledge on that. He too reviewed the case law relating to application of the illegality defence to a tortious illegality or unlawfulness, and he found, you see at paragraph 55, Servier is unable to cite any precedent for saying that a claim for money otherwise payable under English law offends the doctrine of illegality if it arises from a contract involving the commission of a strict liability tort, narrow ground, whether as the object of the contract or its performance. And then at paragraph 56, there are very few reported cases in which the doctrine of illegality has been applied to tort, more widely than that. And he differed in his approach from Lord Sumption insofar as he was not critical of the Court of Appeal in that case, having applied, if you like, this is pre-Patel, of course, but having engaged the defence and looking at the policies underlying the prohibition transgressed. He was not critical of the Court of Appeal having done that, and that he says that at paragraph 62. I would therefore make no criticism of the Court of Appeal for considering whether public policy considerations merited applying the doctrine of illegality to the facts of the present case. In doing so, it adopted a similar approach to the majority in Hunger and Allen. But it's important in my submission just to note the actual circumstances in which the Court of Appeal did that, and which Lord Toulson does that, insofar as whilst Apotex was concerned with a civil wrong, it was a civil wrong which had, of course it was hypothetical, hadn't happened yet, but the illegality relied upon would have involved a conscious breach of a known patent for commercial gain. And one can see how it arguably offends, permitting that claim would offend against the public policy engaged by the illegality defence of not allowing a claimant to profit from their wrongdoing. That's not a principle which applies in a personal injury case such as this, where there's no attempt to profit, but you can see why, in a commercial case such as this, it might be arguable that the breach did so. And we can see that that was an important part. This culpability, if you like, was an important part of the decision of the Court of Appeal in Le Laboratoire. By turning to the judgment of Lord Justice Etherton, if I take you to page 1869, at paragraph 1869, paragraph 76. This was a paragraph which Mr. Warnock referred you to yesterday, and it's where Justice Etherton is saying, I reject a bold proposition that where illegality is the infringement of a patent, the defence can never apply unless the claimant was aware of the patent, knew it was valid, and intended to infringe it. We need to look more carefully. It depends on the circumstances. And he goes on, 3 rows down. Mr. Watson and Mr. Toledano, the counsel in that case, describe the infringement of a patent as a tort of strict liability. There is an obvious difference, however, between inadvertently committing an offence or a civil wrong of strict liability, that is to say, without knowledge of the relevant facts and of the law, and the situation here, in which Apotex, with full knowledge of the Canadian patent, was willing to take a conscious commercial risk that it was invalid. And on that basis, they apply the series of considerations as to whether the illegality defence should arise. In fact, they all come to the same agreement that it should not, and the reasoning in my submission is significantly based on the fact that, I'll take too long on this if I'm not careful, but culpability was an important part there of which would have engaged the claimant or allowed the claimant to profit from a wrongdoing. When they look at it more carefully at the sort of granular level, applying, if you like, the equivalent of the trio of consideration, they don't consider that there was sufficient to engage the defence.
So are you accepting then that in Apotex the threshold, as we now know it to be, was crossed, but you say that's because this was allowing someone to profit from their wrongdoing rather than because of moral culpability? Is that what you're saying?
My lady, what I'm saying is, in summary, the judgment of Lord Sumption holds good and remains the controlling authority on the question of what can amount to a turpitude or an illegality. I'm conscious of the submissions made and the concerns this court will have about the fact that Lord Toulson and Lord Sumption took a different approach to Apotex. And that is, in my submission, a different approach to the next question, not to the threshold question. But it comes about in a set of factual circumstances where there was culpability and profiting from wrongdoing on the face of it. So fair enough, go to the circumstances. But it was arguable, it didn't have the same language there, but it was arguable that it was engaging the public interest in the same way as...
I'm sorry, I didn't hear that.
It's arguable that it's engaging the public interest in the same way that a crime does for the purpose of illegality, because it engages the public interest in not allowing a person to profit from their own wrongdoing. Doesn't apply to this case. But our primary submission is Lord Sumption's judgment in Apotex about what amounts to a turpitude remains good law, and there's nothing in that was overruled in Patel and Mirza, and it can't be taken to have been intended to inadvertently overturn this part of the decision, which is consistent with Patel. That concludes my that part of my submission. So looking at the 4 different categories or areas that Lord Sumption looked at in as to answering the question what amounts to a turpitude. And the next part of my submissions relates to the fact that there was no illegality in Mr. Lewis-Ranwell's case to engage the defence. But in order to make that submission, I need first, I think, to look more carefully with you at the criminal law and how it treats insanity.
I see, but just before we leave Apotex, I was looking to see what Lord Toulson said about the what you've been calling the threshold question. And there is an interesting sentence in paragraph 57, which is on page 1898, where he says that towards the end of a paragraph, in deciding whether the principle should be applied in circumstances not directly covered by well-established authorities, it's right to proceed carefully on a case-by-case basis, considering the policies which underlie the broad principle. So I suppose that's a classic common law method.
My Lord, I'm sorry, I didn't get the paragraph number.
Oh, I beg your pardon. 57 on page 1898. The argument there, as you know, was that the threshold was crossed by the commission of a tort of strict liability, and that argument was rejected, but 57 Servier relied on Lord Mansfield, and you'll see he says that that doesn't provide a simple measuring rod, and then says what I quoted a moment ago.
Yes, my Lord, we thank you for that. And my submission is that that's not addressed to that threshold question, whether there is something which offends against the underlying principles of the public policy questions with which the illegality defence is concerned. Yeah,
and then he then cites the various dicta that support that approach.
Yes. Excuse me.
Yes, I wonder if it's right to say that Lord Toulson was merely talking about the next stage, because...
No, he's not.
He's not?
No, definitely not.
No, because when you go to the paragraph 64, I think you get to the heart of the dispute between Lord Sumption and Lord Toulson, which is the case of Tinsley and Milligan.
Yeah.
And in Tinsley and Milligan, there was a strict rule that if you relied on an illegality in your pleading, had to rely on illegality in your pleading, you were out. And that, of course, created the difficulty that if you were a defendant, you might be able to be in a completely different position from the claimant. And also, it would have excluded Miss Hunger's claim in Hunger and Aaron.
Yes.
And that was, as I recall, Lord Toulson's concern in several of these cases. So he was attempting to, Lord Sumption was attempting to uphold Tinsley and Milligan as a test and row back on its consequences by virtue of his formulation of turpitude. Lord Toulson was saying, no, there's a more nuanced approach as to the threshold, as Lord Reedus just mentioned. Yeah. That's my recollection, because I was in, as you probably know, several of these cases.
I certainly do, my Lord, and grateful for that exposition. I think the point is that I seek to make is that there's nothing in Patel which overrules that question of what can amount to a turpitude.
But Lord Toulson is not signing up to a strict turpitude test as the threshold. No. That's the point.
Yes, I mean, if you look at the very beginning of this judgment on page 1896, he puts the point in a nutshell in paragraph 46. In this appeal, Servier is attempting to extend the doctrine of illegality beyond any previously reported decision in circumstances, which is obviously what is true in this case too.
Yes.
In circumstances where I see no good public policy reason to do so. Then he explains the background, and he goes to the argument at paragraph 54. Servier argues that Apotex's claim is barred by the doctrine of illegality. Then he explains how that claim is put, and the basis of the argument is that the performance of the relevant contract would have involved the commission of a strict liability tort, and under Canadian law. And then paragraph 55, Servier is the problem Servier is unable to cite any precedent for saying that a claim offends the doctrine of illegality if it arises from a contract involving the commission of a strict liability tort. Then he looks at some cases about the application of doctrine of illegality in relation to torts, and then the passage of paragraph 57 that I just went to, where he says that in deciding whether the principle should be applied beyond the existing authorities, you have to consider the policies which underlie the broad principle, and then gives us really statements to that effect from Lord Wright, Lord Hoffman, Lord Phillips and Lord Wilson in the authorities. So he's talking about this is all about the threshold issue.
I'm very grateful for that. And I suppose there's two brief points. Your Lordships have them all anyway. But firstly, that if there is to be an extension to the application of a public policy defence, one has to look at the public policies which underlie the use of that defence, particularly when it is such a draconian defence, judicial abstention. And the underlying principles of that involve consistency, but also involve in that culpability, that there's a requirement for there to be something which goes against consistency and which is wrongdoing. It's a defence about the claimant's wrongdoing, which we in a more modern world call consistency. But the Lordships have my submissions in relation to that. The narrow submission is that that part of Consumption's judgment has not been overruled, and the broader submission is that is consistent with the policies underlying the defence. Excuse me, I just look at the time and have a quick think. I was going to move on to look at the criminal law in a little more detail. And we deal with this in the written case. It's section E, which is at page 231, paragraph 28. But I don't propose to repeat here. I wasn't asking you to turn to that. It was really for your note. But I don't propose to repeat here the rehearsal of the ingredients of murder and manslaughter and diminished responsibility. The broad point is a simple one. It's the simple point that the heart of this case is the claimant is not guilty of a criminal offence. His acquittal on grounds of insanity is a full and complete acquittal of criminal liability. And we emphasise, as does the President in the Court of Appeal, Dame Victoria Sharp, at paragraph 139 of the judgment, which is at page 308, a principled distinction drawn by the criminal court between diminished responsibility, manslaughter, and insanity, and the scrupulous exercise, those are her words, undertaken by the court to distinguish between them. And that is the 2-week trial here on precisely that distinction. That's what the trial was about, only that distinction. And the burden of proof in that trial was discharged by Mr. Lewis-Ranwell. And the finding of the jury, having seen all of the harrowing evidence which they saw, having heard the evidence of the 3 psychiatrists, undertook an examination of that question of culpability, which led them to the answer in relation to criminal liability. He was not guilty. And it's important to emphasize this. It's not just a jury point. There is criticism, of course, we're all very aware of it in relation to the insanity defence. But despite that criticism over some years, the criminal courts and Parliament continue to apply McNaughton insanity as a distinct defence and a complete defence, unlike diminished responsibility manslaughter. And the defendants seek to diminish the difference between these 2 defences by, in effect, criticising the McNaughton insanity defence. And they find some support in this academic and the Law Commission's views. But the law hasn't changed. And that was the basis of the trial, and it wasn't something that turned on a nice decision in my submission, as has been suggested by the appellants. It was a question of whether he knew what he was doing was right or wrong. He could know that. It might be a question of degree of the mental illness operating on the individual's mind at the time of it. But it's not a question of, it's not just a question of degree once the verdict is established. It's guilty or not guilty. It's binary. And juries are well placed and well used to dealing with these very questions. Was there consent or wasn't there? Was there a crime or wasn't there? But I didn't want to lose in going to the detail of the criminal law, that essential point of our case.
Before they arrive, in the judge's summing up, did she explain to them what would happen to the defendant on the basis of either...
No. I will double check that, but no, she didn't explain. Do you mean that he will have one kind of detention or potentially another? Is
yes.
That what the relationship means? No. No.
Diminished responsibility wasn't.
Just to look at the insanity defence, it's helpful to look at a summary of the history of it, because the way in which it's developed is important to the cases. It's well addressed, the history of the insanity defence, by Mr. Justice Johnson in the recent case of Traylor and Kent and Medway Social Care Trust, which was a 2022 case. I'm not going to take you to that case now, but just it's a good place for you to have in your note to look at the history of the
reference, please.
Yes, it's at the case starts at page 2515 of your bundle, and Mr. Justice Johnson is considering the specific question of insanity at 2524. In that case, the claimant had stabbed his daughter whilst he was psychotic, and he was shot by police in order to keep the daughter safe. And he was tried and found not guilty by reason of insanity for stabbing his daughter. He brought a claim against the Medway Social Care Trust, and he failed to establish breach of duty in that case. But Mr. Justice Johnson nevertheless gave detailed over to judgment on the illegality defence, and very similar arguments as here, and was close in time to this case. May I race you through the historical development, just highlighting a few points where we say it's of importance, the changes are of importance. Before 1800, if a defendant in a criminal trial established that they were insane, they were acquitted and released. In 1800, Parliament enacted the Criminal Lunatics Act. That's at page 944 of your bundle. It's very dense to read because it's the original type of it.
Sorry, the page again, please.
944.
Thank you.
But there were three key points I wanted to highlight about that Act. It's expressed from the preamble to the Act that it's introduced due to concerns about safety. So if you're acquitted and released, might be safety concerns for the public. And so the Act asks that upon such an acquittal by the jury, they are required to find specially, the word, it's an interesting word, they find specially whether such a person was insane at the time of the commission of the offence. And that, where that was decided, that finding led to detention at His Majesty's pleasure to meet those safety concerns.
Well, and also they're required to declare whether such a person was acquitted by them on account of such insanity, which sort of allows for the self-defense scenario, for example, what we talked about yesterday.
Sorry, I didn't hear the perfect thing.
They have to, The jury are required to find specially whether such person was insane at the time of the commission of such offence, and to declare whether such person was acquitted by them on account of such insanity. So in other words,
Yes.
The possibility was recognised even then that you might be acquitted for some reason other than insanity, such as
Yes.
self-defence,
Yes.
for example.
Yes, thank you. That Act, the Criminal Lunatics Act, was revisited in 1883, page 1027 of the bundle, in the Trial of Lunatics Act. And the 3 points that I highlight about the changes here is, firstly, there's an introduction of this terminology, special verdict, for the jury's finding. So coming out of their specially finding, we now have a special verdict. There's also a change from the 1800 Act, which had talked about the defendant committing an offence, to the changes to the words doing the act or omission that was charged. Interestingly, though, in the same Act, they perhaps confusingly changed the terminology to guilty of the act but legally insane, whereas it had been an acquittal and not guilty before. But he was still detained at Her Majesty's or His Majesty's pleasure under the criminal lunatics legislation. And the effects of those changes of this Act were considered in the case of Felsted and the King, which is at page 1466. Bundle, and this is a decision of the House of Lords in 1914. Mr. Felsted had injured his wife and was found to be insane and was acquitted As a consequence, he was detained, and he wanted to appeal the finding of insanity. But the Criminal Appeals Act of 1907 only allowed for appeals against a conviction. So the House of Lords had to consider the meaning of an insanity verdict. Was it an acquittal or was it a conviction? And Lord Reading, giving the President of the Court, finds that it was, or the Court found that it was, the Court sat with 6 judges, interestingly, rather than 7 or 5, but the Court found that it was an acquittal, not a conviction. It does draw your attention, if I can invite you to go to page 1475, where the arguments are being considered that the use of the word guilty in the 1883 statute suggested that there was residual or some responsibility for a criminal act. And the response of Lord Reading to that is this, page 1475. Sorry, yes, just at the bottom of the page. No, just sorry.
It's the second half of the second paragraph.
Thank you. The Court was largely influenced, the court below, to their conclusion by reason of the use of the word guilty in the special verdict. It is unfortunate that this word is there, used as it suggests the responsibility for a criminal act. If the requirement under the statute had been merely to find that the accused did the act, instead of that he was guilty of the act, there could have been no room for doubt that such a verdict was not a conviction, but was an acquittal. It's also, if you look down to the bottom of that page, it had been a submission that the term of criminal lunatics intended, could be read into that there was some criminality in the defendant. And at the bottom of page 1475 and going over, the special verdict is, in my opinion, one and indivisible by reason of the statutory provisions. I'm sorry, I've taken you to the wrong bit. I'm sorry. page 1474, and it's at the bottom of the second paragraph there. You can see they're considering whether the special verdict, because he's gone to be a criminal lunatic, it was submitted that the legislator must have intended the special verdict to operate as a conviction of a crime. In my judgment, this contention is not well founded. By the use of the term criminal lunatic, the legislature meant by compendious reference to bring into operation the powers given under the statutes and later statutes, which provided for detention in certain asylums and under certain conditions of people found insane and those acquitted under the aforementioned Act. But the fact that it involves the Criminal Lunatics Act does not assist the appellant in that case in saying that he was convicted or that there was some guiltiness in it. The further relevance, two more points about this case. First is to go to the question of mens rea.
Still in Felsted.
Still in Felsted.
Yes.
The bottom of the first paragraph.
Page.
Which page, please?
Oh, I'm sorry, 1473.
1473. We're going backwards now.
I'm sorry, no, it's not 1473. It's because I've scrolled. It's 1474.
1474.
I apologize.
Right.
Bottom of the first paragraph.
Yes. In other words, this verdict means that upon the facts proved, the jury would have found him guilty of the offence had it not been established to their satisfaction that he was at the time not responsible for his actions and therefore could not have acted with a felonious or malicious mind, which is an essential element of the crime charged against him. And in this next paragraph down, it is obvious that if he was insane at the time of committing the act, he could not have had a mens rea, and his state of mind could not then have been that which is involved in the use of the term feloniously or maliciously, for crimen non contrahita nisi voluntas nocende intercedat. That's my best Latin. I went to school post-Latin.
In this case, we know from the medical evidence that was before the jury that it was the second limb
We do.
of the McNaughton rule which was in play.
Yes. And the submission made, which my Lord is very alive to, the submission made on behalf of the appellants is that because it was the second limb of McNaughton and the question of wrongdoing, there hasn't, that one could say that Mr. Lewis-Ranwell had the mens rea as well as the actus reus of the offence, and we say that's a misstatement and misunderstanding of the law. And that's the point that I'm seeking to develop now by looking at these cases. No, I should have made it clear.
Take you out of the order of your submission.
When Lord Reading is looking at this question of mens rea in Felsted, he is using, in my submission, mens rea in its literal and broad sense, a guilty mind. He is encompassing more than merely intentionality. He's talking about the guilty mind of a criminal, something that's felonious, guilty mind of a criminal. And that's a thread which we need to follow through into later cases. But that was the point I wanted to take from here, from Felsted. And there's a final point in relation to...
Sorry, and you base that just on the word feloniously, because maliciously would be part of the intent, wouldn't it?
Well, my lady, I think the point he's making, he says it's obvious that he would have no, if insanity has been proved, it is obvious that he would have no mens rea because he doesn't have a criminal mind. I think that's how I'd summarize that. But this question arises in subsequent cases of Crown and Antoine, which I'll come on to look at. But before we leave Felsted, I take you to the bottom of page 1475, and a further point I want to make, which is that Mr. Felsted had wanted to appeal against the finding of insanity rather than the fact he had done the acts, or done the acts. It was the view of the House of Lords that the special verdict, this is the very bottom of page 1475, is, in my opinion, one and indivisible by reason of the statutory provision, the 1883 Act. It takes the place of the general verdict of not guilty, and it is a verdict of acquittal of the accused. And in coming to that view, the House of Lords have overruled a previous case of McAdee, where it had been held that the verdict could be divided into two and the factual part of it could be appealed. But Lord Reading has said, no, it's one and indivisible. It is a verdict of acquittal of the accused. The next stop on our whistle-stop tour of the development of the insanity defence is, that I wanted to draw to your attention, is the 1964 Criminal Procedure Insanity Act, which is at page 946.
Sorry, 9466.
946.
946.
Sorry. And it's section 1 of the Act. And you can see there that the special verdict required by section 2 of the Trial of Lunatics Act 1883, hereinafter referred to as a special verdict, shall be that the accused is not guilty by reason of insanity, and accordingly, in subsection 1 of that section, for the words from a special verdict to the end, there shall be substituted the words a special verdict that the accused is not guilty by reason of insanity. It's under the title acquitted on grounds of insanity. And we say that this is a reflection in the legislation of what had already been held to be the law in King and Felsted. But it's just important to note that in 1964, some 60 years ago now, the Parliament considered it was important to leave no doubt in that, to clarify that the special verdict is a finding of not guilty. A person who is insane when they do an act, that's all that was required to do an act, is not a criminal. Just for completeness, I should take you to page 1027, which is this was...
Can I just be clear one thing? Just looking at diminished responsibility, insanity, and unfitness to plead. Is this right, that if you're dealing with diminished responsibility, either there will be a trial and that will be the jury's verdict, or the defendant will plead to that?
Yes.
If you've got a conviction of if the defendant argues that he was insane at the time, there will have to be a trial as to that.
Yes.
You can't just plead to that.
That's correct.
And that trial will determine whether he did the actual actions, and only if he did the actual actions and there was no other defence, like self-defence, accident, whatever, will there be an acquittal by reason of insanity?
There's a nuanced answer to that last part. So what the Crown has to prove is that he did the acts.
Yep.
That's clear from the legislation. And the Trial of Lunatics Act, as amended, is at page 1027.
Had to prove that he did the acts such that if he was not insane, he would have been convicted of murder.
Yes.
Right.
So had to prove that he did the acts. What's difficult in that, as the case of Attorney General reference, which Mr. Bullock took you to yesterday,
And Antoine,
is that doing the acts is potentially over-inclusive. So the example given in Attorney General reference of a person swimming in a swimming pool who may have touched somebody, if all that has to be proved is that they did the touching, we don't know whether they've done acts which, if done by a sane person, would have amounted to a criminal offence. And so both Attorney General reference and Crown and Antoine grapple with what to do in such circumstances. Because normally...
But the conclusion they arrive at is that you do have to rule out the conclusion, potential defences before you arrive at a not guilty by reason of insanity, isn't that right?
Well, in my submission, the conclusion that they arrive at, and perhaps we can just go straight to that and shorten my submissions. The conclusion that Lord Hutton arrives at in the judgment of the House of Lords in Crown and Antoine in answer to that difficult question is given at from paragraph 85 of, and let me just give you, sorry, this is unfortunately in the supplementary bundle.
Yes.
Well, just for our note, perhaps we can...
well, at 85, between F and C, page 85 of the supplementary bundle, I'll leave you to read that because it is complicated, but in our submission, in simple terms, what Lord Reading says is the prosecution must prove the act and disprove any innocent explanation where, but only where, there is objective evidence of such a defence.
Yes, well, that's the self-defence anyway. You only have to disprove it beyond reasonable doubt if it's raised by the defendant in an ordinary trial.
Yes, he says what you can't do is make a submission that the prosecution haven't gone on to prove that there was this or that. And he thinks that that treads a good balance. And my submission in relation to that, I hope I'm not speaking
can I
over
just
you. Yes,
then, with unfitness to plead in section 4, then is no trial of the criminal offence in a sense, but there then has to be, is this right, under section 4A, a jury impanelled to decide whether he did the act or made the omission charged against.
And in Antoine, they treat them as similar. Yeah. And my submission is that in Antoine, this offers a sort of practical issue with how to manage these difficult questions in the criminal court when undertaking these inquiries for the purposes of addressing public safety. Nothing in it alters the fact that a person who's insane at the time of doing an act is not a criminal, and he doesn't have a criminal mind. In the same way that there's been no criminal act, only an act which, if done with a guilty mind, would be criminal. And it may be that I've, in leaping over the submissions to answer that point, missed a step there. Just conscious of time, but if I take you to the House of Lords in Antoine reviewed the position about mens rea as well. And I think this is worth going to the supplementary bundle if it's available too.
Yes. Which page?
Page 81. Mine's shrunk. Lord Hutton is considering the judgment of Lord Justice Judge in the Court of Appeal in the Attorney General reference. And he finds that, he says that Lord Justice Judge had
found there was no need to establish mens rea on two grounds. First was the words of the statute, did the act. It had been changed, and Lord Hutton says, consider that Lord Justice Judge was right to state the contrast between the words committed the offence in the 1800 Act and the words did the act in the 1883 Act points to the conclusion that the word act does not include intent. And
this is at letter G.
Mm. Yeah.
Thank you. And secondly, he agrees that he is. And secondly, he says that Lord Justice Judge made that finding on the basis of Felsted and King, and the phrase "it's obvious that he was insane at the time of committing the act, he would not have had mens rea." And if you look at page 82, H, or just above H, actually, about G, counsel had submitted in that case that if a defendant is acquitted under the McNaughton rules on the basis of ground 2, that he did not know what he was doing was wrong, he could still have an intent to kill, and therefore the statement of Lord Reading in Felsted and the King that it's obvious that if he was insane at the time of committing the act, he could not have had the mens rea, required qualification and was not right in all of the circumstances. And this is an argument that I think that the appellants are making in this case, because in doing so, similar argument.
That's rejected very
well. Just to stay with it before the rejection, if I may, that counsel's treating here in my submission mens rea not in its full sense, a guilty mind, but in the narrow sense to refer to the specific state of mind required to prove the offence of murder in a sane person, intention to kill. And Lord Hutton didn't accede to that submission, and he responds at page 83, just below B. My lords, a person who kills when he is insane because he does not know what he is doing is wrong may have the intention to kill, but I consider that insanity under either limb of the McNaughton rules negatives the mental responsibility of the defendant. Cites Lord Diplock in Crown and Sullivan. And then he goes on. Moreover, in some cases, it would be very difficult to decide if one limb applied or another. But he goes on to say, sorry, I just got it better. Yes, he's talking about a particular evidential difficulty, but then at the bottom, accordingly, where it is established that the defendant was insane under either limb of the McNaughton rules at the time of the alleged offence, the jury should no longer be concerned with the mental responsibility of the defendant for that offence, and a jury making a determination under section 4A2, they're talking about trial, fitness for trial at that time, should not consider the issue of mens rea. The defendants advanced their argument by reference to the case of Loke, which is at page 1900 of the other bundle, the main bundle. And we deal with this fairly fully at page 236 in our written submissions from paragraph 42. But in brief, if I may, the defendants or the appellants are averring that the claimant, Lewis-Ranwell, had the actus reus and the mens rea of the offences, and that therefore there is residual criminality. There are criminal acts, even if there isn't a criminal actor. And our submission is that these misstate the criminal law. They don't assist the court. Well, firstly, they misstate the criminal law, and secondly, they don't assist the court with the decision today, which is whether the illegality defence should apply to this case. As Lord Justice Underhill says, for your note at paragraph 96, page 299 of his judgment, the criminal law is not concerned with acts alone, but with a defendant's responsibility for those acts. And secondly, in Loke, you'll remember from looking at the case yesterday that the defendant was charged with an objective liability offence under the Protection from Harassment Act. And the prosecution argued that the defence of insanity only goes to the question of mens rea, and therefore it's unavailable in an objective liability offence. And the court rejected that submission and confirmed that the defence of insanity is of general application because it rests on a broader basis than simply absence of mens rea. And Lord Justice Irwin cites and emphasises, or cites the judgment in Crown and Antoine at page 1915, you can see that. Paragraph 60.
Paragraph?
I just said paragraph 60, but I'm just worried that I've done that, sorry. I perhaps don't. Let me just see pages 35. Yeah, at paragraph 43, my apologies, which is at page 1910. Sorry, it's not. It's at 1912, 1912, paragraph 43. He cites Lord Hutton in Crown and Antoine. My lords, a person who kills when he is insane because he does not know what he's doing is wrong may have the intention to kill, but I consider that insanity under either limb of the McNaughton rules negatives the mental responsibility of the defendant. And he notes also in the course of his judgment a passage from Professor Hart, which is perhaps interesting in light of the academic literature cited to you yesterday. Apologies, I'm going backwards, but that is at paragraph 35, page 1910. At the heart of the rationale for the insanity defence is the principle that criminal punishment should only be imposed upon those who are responsible for their conduct. As Professor Hart put it in Punishment and Responsibility, what is crucial is that those whom we punish should have had, when they acted, the normal capacities, physical and mental, for doing what the law requires and abstaining from what it forbids, and a fair opportunity to exercise those capacities. Where these capacities and opportunities are absent, as they are in different ways in the varied cases of accident, mistake, paralysis, reflex action, coercion, insanity, etc., the moral protest is that it is morally wrong to punish because he could not have helped it, or he could not have done otherwise, or he had no real choice. And in illustrating the fact that insanity rests on a broader basis than intentionality, Lord Justice Irwin gives the example of the defence applying to a person who is acquitted under McNaughton 2. And he says, at paragraph 41, page 1911, it is possible for someone to have the full mens rea for a criminal offence, whilst at the same time, because of a defect of reason arising from a disease of the mind, not knowing what he was doing is wrong. And in my submission, what he's doing there is he's using the term mens rea in its narrow sense to mean that he knew the physical qualities of his act. He knew that the killer knows that in putting the knife, that is going to kill. And if you were sane, that would supply the mens rea for the offence. But it doesn't in an insanity case. So there is over to comment here from Lord Justice Irwin, which suggests that you could have both the actus reus and the mens rea if you're acquitted under Ground 2 of McNaughton. But as we know from both Felsted and from the 1964 Act, as the law currently stands, Insanity Act, all that is established in the trial is that he did the act as it was charged, and that once insanity is established, the negative responsibility of the claimant, or that negatives the mental responsibility of the defendant, as it makes sense. He's so insane as to not to know what he's doing is right or wrong. He doesn't have a guilty mind, a felonious mind or guilty mind on the wider basis. He doesn't actually comment on his intentionality. The insanity, once established, demonstrates that he doesn't have the mental responsibility to commit a crime. What I noted here, as Justice Lloyd Jones did yesterday, notably, if the defendant's argument is accepted and there is to be this line drawn on the basis of whether you were aware that putting the knife in would lead to bodily harm or death, or whether you knew whether what you were doing was right or wrong. If that was the relevant distinction for the purposes of the illegality defence, then you would have a much finer distinction than that between diminished responsibility and insanity. And you would risk introducing here a different test into the civil law than you have in the criminal law. And you'd be departing from, and that's a similar attempt was made by the court, a similar attempt was made by the claimants in Henderson's case and was rejected by the court. It's necessary for the civil law to cleave to the criminal law in this respect. And I'll come on to look at that in Henderson later. Briefly, as to the academic law you were taken to yesterday, actually, I'm going to leave that just because I think there isn't enough time for me to do that.
Yes, that's perfectly all right.
I could make this point that in the skeleton argument for the Court of Appeal, we did respond more fully to the academic law points which were being made, and that skeleton argument has been included by the appellants in the bundle, and the academic literature is dealt at paragraphs 20, 21 and 24 there, at page 4970 of the bundle.
Thank you.
Move on to the question of, so we say no crime. No punishment, it's the next heading that I have. We need to consider the disposal of the criminal courts when somebody is found not guilty by reason of insanity. As set out in our written case at paragraph 32, where a person has been acquitted on grounds of insanity, his mental health and the safety of the public are considered before he leaves the court. By virtue of sections 5 and 5A of the Criminal Procedure Act, which I will ask you to turn up, is at page 948. Starts at 947. By virtue of section 5 and 5A of that act, as amended, where the offence charged is fixed by law and the court has the power to make a hospital order, then the court is obliged to make that hospital order with a restriction order, so section 3741. So looking at that power,
So are the provisions in section 37 and section 41, those are for offences where the sentence is not fixed by law?
Well, section 37 and section 41, I can take you to section 37, that's the important thing here. Just if we just note, Lady, on this page, that the, whilst you've still got the Criminal Procedure Act in front of you, it's section 5(3) B. So you have to have the power to make a hospital order, and hospital order has the meaning given in section 37 of the Mental Health Act, and it's from section 37 that the power to make that order would then derive. And section 37...
So what does section 5 do over and above section 37?
It provides a route because
provides a route for what?
It provides a route for the criminal court after a finding of insanity to either absolutely discharge, to make a guardianship order, or to make a hospital order, and to say that if it's a case of murder or manslaughter that's being charged, then the court is obliged to make a hospital order where it has the power to do so. But that power comes through section 37.
Is that right? The Mental Health Act, if you look at it by itself, is concerned with health treatment. And, for example, you would need to have somebody certified on appropriate medical evidence before he could be committed to a mental hospital. But we're looking at the moment at a Criminal Justice Act, and this is providing a different route into mental hospitals, which applies where we're told a special verdict is returned that the accused is not guilty by reason of insanity. And so, in other words, it's to do with a jury, the consequences of a jury's verdict in criminal proceedings. And we're told that under subsection 2 what the general position is, and under subsection 3 that where, as for example in a case of murder, the offence is one for which the sentence is fixed by law, then there has to be a restriction order as well as the...
or that there has to be a hospital order.
As well as the hospital order.
If section 37 also deals with where a person is convicted of an offence.
So yes. So section 37, section 5 provides a route to make a hospital order under section 37 of the Mental Health Act, which is at page 988, is normally the section which is used if a person has been convicted of an offence. That the Crown Court, before they leave court, obviously they've been convicted of an offence, and the court wants to make a hospital order, then it's section 37 it provides that. Section 37 before...
I'm sorry, is that 37(1) is dealing with people convicted of offences other than offences the sentence for which is fixed by law?
Yes, and the...
Yes. Well, that's what I'm trying to work out. Is use 37(1) where it's an offence which is not a punishment which is fixed by law, and section... But section...
No, I'm sorry. This is coming back to me from about 20 years ago, and I used to actually do this. This is dealing with people who are convicted.
Yes.
That's the whole point.
Sorry, to make it clear. I should have stayed a little bit longer with the Criminal Procedure Act, which is on page 948. So section 5... it provides this route. You can make if you have the power, then you should make the hospital order. If you go down to section 5A, Section 37, as you say, of the Mental Health Act relates to people who have been convicted. Section 5A of the Criminal Procedure Act, 1964, says that in relation to the making of an order by virtue of Section 2A of Section 5 above, Section 37, hospital orders, the Mental Health Act shall have effect as if the reference in subsection 1 to a person being convicted before the Crown Court included a reference to the case where Section 5 above applies. So it... Yes, you're ahead of me.
Go ahead.
But I still... What is this business about whether it's an offence for which the sentence is or isn't fixed by law? Why is that different in Section 5.3a? Because that seems to then be dealing with a different set of offences from what Section 37 is dealing with, and not anything to do with whether they're insane or unfit to plead.
The hospital order and the basis on which you can make a hospital order is provided by Section 37. But if one read Section 37 without the benefit of the Criminal Procedure Act, it wouldn't appear to apply to a person who's been acquitted by virtue of insanity.
But nor does it appear to apply to somebody who's convicted of an offence which is an offence for which the sentence is fixed by law. What happens if you're found not guilty by reason of insanity of an offence for which the sentence is not fixed by law?
In paragraph 5 of the Criminal Insanity Act, section 1A, this section applies where a special verdict is returned is not guilty by reason of insanity, and at subsection 2, the court shall make in respect of the accused a hospital order with or without a restriction order, a supervision order, or an order for his absolute discharge. So in the case of somebody acquitted on grounds of insanity who's been charged with an offence other than murder or manslaughter, you can make a hospital order, a supervision order, or you can absolutely discharge him. The difference in cases of where the sentence is fixed by law is that there is a requirement to impose a hospital order, or to make a hospital order with a restriction, 3741, if you have the power to do so.
So, in other words, you cannot order his absolute discharge. Or a supervision order. You must make the hospital plus a restriction order if there is.
If the medical evidence satisfies the.
But if you've got an insanity
verdict. 37.
If you've got an insanity verdict, is it ever not going to?
Yes.
And I suppose unless there's a change in.
It can be a change. And,
no, because you can have an insanity verdict for any offence, I thought. Not just for murder.
Yes, but then subsection 2 applies.
Section 2.
You've got discretion.
So the difference... So subsection 3 is just making it mandatory in a subset of cases.
Yes.
Right. But all cases where people can be... Section 37 deals with all cases where a person is convicted.
Yes, unless read through the lens of Section 5A. Criminal Procedure. But in Mr. Lewis-Ranwell's case, his mental health was of his mental disorder was of a nature or of a degree at the time, we say nature, at the time of the sentencing, that the medical evidence could satisfy that. We don't question that, and that a hospital order with a Section 41 was therefore going to follow as it did. My point of drawing your attention to this is that the acquittal from a charge of murder on grounds of insanity doesn't automatically lead to detention in a mental health hospital. It's not about that. The acquittal from a charge of an acquittal on grounds of insanity means that if a hospital order is made, it's made for your treatment purposes and for protection of the public. That's a part of what is looked at. But it's not because you've done something wrong. There's no punishment in that. It's not reliant on those acts in that way. And if the fact that a hospital order, if the fact that the court had the power to make the order and therefore had to do so in this case, if that's to draw the line for the purposes of the illegality defence, what of this situation? A person who had done the acts charged and then was no longer had a mental illness of a nature or a degree that required a hospital order at the time of his sentencing, and was absolutely discharged, as he would be, he wouldn't face the illegality defence in bringing a claim like this. Is that where the line is to be drawn? But the fact that the claimant in our case requires treatment for longer, is arguably more mentally unwell, does that make his acts more turpitudinous, more quasi-criminal? Does that give him residual criminality? And the error here is that the appellants say, well, the interests of the state are engaged through the fact that there is this power to detain the claimant. Well, I think the slip happens here, that the powers of the state to look after somebody and to treat them compulsorily, and the powers of the state to safeguard the public, one can say loosely they have a public interest, but it's not the same public interest that the illegality defence is founded on. It doesn't provide a good public policy reason for extending the illegality defence. It is a treatment order. And the fact that Mrs. Henderson, for example, Mr. Gray, also received Section 3741 orders, was an argument that Mrs. Henderson tried to use in her favour, and unsuccessfully before this court, to say that, well, it's the same as would be given in an insanity case. And that was dealt with in this way by the court. Whilst the order itself may not have had a punitive effect, the fact of the conviction for manslaughter and the sentence, the fact that this comes as a sentence, not a disposal, that has a punitive effect. That is the condemnation. And Henderson is at paragraph 109 where this is said. And at page 1743G. No, I'm so sorry. Is that right?
That is paragraph 109 of Henderson.
It's not in mine. Thank you. Well, nor does the fact that there may be no penal element to the sentence imposed by the criminal court in that case matter. As Lord Roger observed at paragraph 78 of Gray, even if the sentence is not regarded as being punishment, this does not mean that the judge was treating the claimant as not being to blame for what he did. A conviction for manslaughter by diminished responsibility still involves blame. Some responsibility for the unlawful killing necessarily remains. And moreover, the fact of a criminal conviction for manslaughter is in itself punitive. There are many circumstances in which the courts public courts manage and detain people. Once you've gone into a hospital under detention under Section 3741, the Mental Health Tribunal will review regularly your detention and will be obliged to discharge you if the requirements for that are not met, or discharge you conditionally. A Section 2 or a Section 3 order under the Mental Health Act involving doctors and social workers, emanations of the state, are overseen by His Majesty's tribunals. A dole's deprivation of liberty safeguard, that can have standard authorization in a care home or hospital, but it can also come from the operation of the Court of Protection. And in personal injury claims, we are frequently claiming for the losses which arise out of such detention, where that detention came about because of the negligence of the defendant, as we say it did in this case. It's a rather long way I've gone around the houses to make the point which I made at the beginning, which on the face of it seems plain. The claimant isn't a criminal, and the criminal law did not treat him as a criminal, and in our submission he should not be treated as one and debarred from the civil courts on the basis that he has acted illegally or immorally. And our submission is that it would be inconsistent with the statutory provisions, 1964, and the criminal law to find any illegality or immorality attaching to Mr. Lewis-Ranwell. And to bar a claim in a case such as this would be just as inconsistent as it would be to allow it in a case of a conviction of diminished responsibility manslaughter. I'm just pausing to look at the no crime, no punishment. I think deal with briefly our submission that there's no quasi-crime. I think these points have probably been made by me along the way. But just to reiterate them, as the President said in the Court of Appeal judgment, Mr. Lewis-Ranwell was not convicted of a crime. It was a quasi-crime. There was no crime at all. We agree with her in relation to that. And for all of the reasons that I've been through in Felsted and King and the 1964 Act above, and the disposal by the criminal court of the claimant, it's distinct from the question of liability, and it doesn't make it half criminal or quasi-criminal. That would be for the tail to wag the dog. The question which took some time yesterday was whether Mr. Lewis-Ranwell's acts can be described as unlawful. The headline point here is the submission from us that there is no concept of objective unlawfulness. There is a system of laws, and unlawfulness depends on the transgression of a law within that system. And here, Mr. Lewis-Ranwell's acts were not criminal. The appellants suggest that he breached, it was in breach of the right to life, but that's Article 2 of the Article 2 rights, ECHR. We note this about that. He couldn't breach Article 2 himself because the obligations which arise under Article 2 are obligations on the state. In actuality, the parties here, arguably in breach of Article 2, were the defendants, and an argument's been accepted in relation to that by the coroner for the inquest. And we note that human rights law, if that is what he's said to have breached, human rights law is not concerned with him bringing this claim. There is not an inconsistency seen there which prevents him from making a claim under the Human Rights Act, and that's accepted by the appellants. So at most, in terms of unlawful, one would say tortious. Morrison, Marsden, or Dunnage and Randall, as they are now, as the cases are, there is a tort. But that is in the context of it being a non-culpable tort. And in the context of the illegality defence, that does not engage the public interest in the same way as a crime. There's nothing inconsistent or incoherent about the claimant being liable to his victims and also being able to seek compensation for his losses, including those arising from that. That's commonplace in negligence. This court, in my submission, can permit his claim to continue without causing any fissure in the law, and the limited power, therefore, should not arise or be used. It is perfectly coherent for there to be different claims looking at the different losses in this claim in the civil court, in this case in the civil court. Mr. Johnson's going to deal later with other aspects of the law of this country which do not treat killing whilst insane as unlawful killing. The coronial law doesn't, and nor does the law of succession.
Are you saying there's an intermediate category between... You wouldn't argue that it was a lawful killing, would you?
In answer to that question, and it's troubled judges through the life of this case, but essentially the law... sorry.
It may not matter, but
well, it may not matter. I think where we come down to on this is the term unlawful isn't helpful.
No, that was where we started at 10:30 this morning.
Thank you.
And
apologies.
And it's a term that needn't necessarily have the same meaning in different contexts. For example, coronial law and criminal law.
Yes. And it's important, but it shouldn't just be used as a gateway through to the illegality defence because you could use the terminology unlawful. And that is, in fact, the approach that Lord Justice Underhill took in the Court of Appeal. He said, well, it doesn't really mean much. I'll use the term unlawful because I find it hard to call killing in these circumstances lawful, but I use it in a neutral way. Apologies, I haven't got that paragraph at my fingertips, but it...
No, but he says that, yes.
Yes. I was going to complete that part of Section 1 and go on to look at the precedent cases and the trio of considerations, and I wonder if that's a convenient moment to break. Or I can begin, if you prefer.
Well, I think it might be better if you were to begin, because I have the impression you're rather short of time, yes, and it's only 7 minutes to 1, so we can hear you for a bit longer.
So this part of my submission relates to how the courts have previously applied the illegality defence where the claimant is killed whilst mentally ill. And it's in Part G of our written argument, paragraphs 66 to 92 at page 242, onwards of the core bundle. And we submit that Lord Justice Underhill was right, and this is at paragraph 31 of his judgment, 278 of the key documents bundle, to note in Henderson that the Supreme Court had emphasised that Patel and Mirza did not represent year zero, and that earlier decisions addressing particular types of situation where the illegality defence was invoked remained of precedential value unless they were shown to be incompatible with the approach set out in it. And it's right, we submit, to look to say that the appropriate lens through which to examine the issue in this appeal is those cases concerning application of the illegality defence to cases where the claimant was mentally ill. They're well known to you, but I will go through them if I may. The first time that appellate courts in this jurisdiction considered application of the illegality defence to a case where the claimant had killed when mentally ill was Clunis in 1997, and the case starts at page 1345 of your bundle. my lords and ladies, are familiar with the facts of the case, but the claimant had suffered a mental disorder and was suing the health authority for failure to ensure that he was adequately treated and detained, which would have prevented him from killing Mr. Zito whilst acting under psychotic delusions. Similar facts on many levels, but of course the crucial difference was that he was guilty and pleaded guilty to a manslaughter by diminished responsibility. The defendants in that case raised the illegality defence, and the claimant argued that where the degree of responsibility was diminished by reason of mental disorder, the court should not apply the defence. That was the argument. And Lord Justice Beldam gave the judgment of the court. And I ask you to turn to page 1354 of the bundle. Paragraph D to E. So will you just bear with me? I've got something strange happening with my thing that is leaping around. Yeah. For some reason it's not connecting the numbers. But at 1354, you can see that Lord Justice Beldam has concluded that the operation of the policy was restricted to cases where the person seeking redress, the claimant, must be presumed to have known what they were doing was unlawful. And he's relying on Adamson and Jarvis and Burroughs and Rhodes as authority for that proposition. You can see that at D, Adamson and Jarvis, from the inclination of the court and from the concluding part of Lord Kenyon's judgment in Merriweather, and from reason, justice and sound policy, the rule that wrongdoers cannot have redress or contribution against each other is confined to cases where the person seeking redress must be presumed to have known what he was doing was wrong. So what he was doing was an unlawful act. And at E, the restriction of the operation of the policy to cases in which the person seeking redress must be presumed to have known that he was doing was an unlawful act was confirmed in Burroughs and Rhodes. And then he applies the law to the facts in this case at page 1356 in the judgment that he gives the ratio really at 1356 D to G. In the present case, the plaintiff has been convicted of a serious criminal offence. In such a case, public policy would, in our judgment, preclude the court from entertaining the plaintiff's claim, unless it could be said that he did not know the nature and the quality of his act, or that what he was doing was wrong. The offence of murder was reduced to one of manslaughter by reason of the plaintiff's mental disorder, but his mental state did not justify a verdict of not guilty by reason of insanity. Consequently, though his responsibility for killing Mr. Zito is diminished, he must be taken to have known what he was doing and that it was wrong. A plea of diminished responsibility accepts that the accused's mental responsibility is substantially impaired, but it does not remove liability for his criminal act. We do not consider that in such a case a court can or should go behind the conviction. And even if we could, we do not see in the medical report any statement which would justify us taking that approach. And on the following line, the plaintiff in this case, though his responsibility is in law reduced, must, in Best CJ's words, be presumed to have known that he was doing an unlawful act. And that, in my submission, is an express and principled distinction for the purposes of the Illegality Act, which emphasises both the criminal liability and the culpability distinction between the defences.
Now, is that a convenient point? Thank you very much, Ms. Plowden. Well, we'll adjourn and resume at 2 o'clock.